So now we're going to figure out exactly what our client has in terms of the data that they've got. So now, how are we going to identify the data and respond to the requests? When we talk about identifying the data with our own client, there's a couple of key things that we need to look at. And again, you don't have to take any notes because this slide is one of the digital handouts that's titled Identifying Data with Your Client. So you just go on Everything eDiscovery's website on the Members tab, and there is this data and information for you. So we're talking about preservation policies, whether they're going to overwrite or delete data. If they do that in a common practice, you want to know that. Like I talked about earlier, any upgrades or changes to their computer system. You want to ask them this stuff because you want to know if it's planned. It's okay if they do it, but they have to tell you, and you've got to make a plan for it because they can get rid of old computers. They just might have to keep the hard drives or keep the data. The IT contact person, usually they have someone in-house or they've got someone that they use outside of the business, for example. That's your hip pocket expert. That's your built-in expert that's handling that data that you can lean on and rely on to have them educate you on how this particular client is storing the data. Preservation policies for paper. Don't forget about paper. We're talking about a whole digital world. We're talking about eDiscovery, but don't overlook the paper because there are still people out there who like to print off emails or contracts and make notes on it and stick it in a file in their drawer. So you want to know what is their preservation policy. What happens when an employee leaves? A lot of businesses have BYOD policies, bring your own device. People come up with their own cell phone, their own tablet, and they bring it into the business. Well, they're accessing the business's servers and all that information, and they're downloading information to it. They're getting their emails on their phone. They're using texts and things like that. What happens when an employee leaves? Because if your case lasts 3, 4, 5 years, in that time span, someone could leave the company, they could be fired, something, God forbid, could happen to them, they could get into an accident, they could get killed. You have to ask your client, you have to know what happens when somebody leaves, what's the policy that's in place. And of course, ongoing obligations. These obligations will continue throughout the case. It's not like you do the search, you get their data, you produce it, and then it's done and you can turn a blind eye to it because it's going to continue throughout the entire litigation. Now, again, on Everything eDiscovery's website are helpful tips and a sample document location questionnaire. And what that means is it's a little checklist for you to use when you talk to your client, either in person, by phone, even by email. You can say, answer these questions for me. I want to know what devices you use. I want to know where this data is. I want to know who has access to it. And then you're taking notes and you're preserving your notes because that's going to insulate you later from liability. And again, the password at Everything eDiscovery is simply I love EE, but all in lowercase. When you identify the data, this is where you're going to look. And again, you don't have to take any notes. This is all a handout on that Members tab at Everything eDiscovery. But you want to look in these types of areas. And probably the biggest one, or the most unique one that gets overlooked often, is voicemails. How many people have a voicemail service in their office that captures the voicemail digitally and sends you an email with the voicemail attached? A lot of people. That is a piece of data that can be stored, that can be preserved, that can be obtained. So someone leaves a voicemail on your client's voicemail service and says, I just signed the contract, we're FedExing it to you. And then later, the issue develops where they don't have a signed copy and they're claiming there was no contract and they say, we never signed it. Now you've got a voicemail captured electronically attached to an email that you can bring up and find through a search of this other party saying, we just signed it and FedExed it. How's that going to play to a jury, huh? So important not to overlook those areas. When you talk about doing due diligence with the client as well, doing your due diligence, and you're looking at what kind of data that they have, you want to communicate with them as often as possible and as much as possible about their data as you're learning about it, as you're asking questions. It's very much an interactive experience. When we're talking about the requests, either drafting them or responding to them, there's a couple of common sense points that come in, reading them, understanding the definitions, and on the Members tab are sample request to produce and eDiscovery interrogatories for you to use and modify however you like. But eDiscovery uniquely requires a lot of cooperation. And for some litigators, that's counterintuitive. A lot of people have been trained or taught, or they have a belief that it's sort of litigation is scorched earth and it's kind of no holds barred. To do eDiscovery properly and to do it efficiently and effectively, it's the polar opposite. It requires cooperation between the parties, but that is not a bad thing because of the uniqueness of electronic discovery, of how it's done. There's no harm in telling people what you want them to search for, asking them to give you search terms. It makes your job and your lives a lot easier. But of course, when you talk about the objections and things, some of the points to keep in mind, and we're very fortunate to have Mr. Adam Rabin here, former president of the Palm Beach County Bar, who was the champion of the button that everybody wears. That is, what does it say again? Got civility. I was going to say be courteous, but I don't think that one made the cut. There were probably others that you went through, I'm gathering, that didn't make the cut. But got civility, the got civility movement, that is a groundswell that has started thanks to Mr. Rabin here in Palm Beach County and has gathered steam throughout the state. Always be professional with the opposing counsel when you're talking about these requests, when you're dealing with this data. No reason not to. Here is some of the elements to plan for document collection with your own client, looking at production requests, time frames, what they're asking for. And there's no harm when you get a request, if you can't understand what they're asking for, to use our post, send them an email, or pick up the phone and say, what do you want us to look for? We've got 170 gigabytes of data. I'm not looking through all this stuff. I'm not going to go on this little scouting mission and try to find the needle in the haystack. Tell me what you want. Tell me the search terms that you want me to use. You can do that. That's the cooperation between the attorneys and the paralegals in the case. No harm in that. When you have complex cases and you're saying, gee, I don't really understand what they're asking for, and now that they're trying to explain it, this is beyond me. I'm not an IT person. That's when you turn to somebody like Connie at Cicada, at your eDiscovery software company, and say, I don't know what to do here. I don't understand this. They're asking me to search in this data, in the client's data, for a source code. I don't even know what a source code is. Connie works in this field on a daily basis, and she's also an attorney. So she's got both sides, the tech side and the legal side. That's the person that you would pick up the phone for your software vendor and say, how do I do this? How do I construct a search for this very specific, very odd information, like a source code file that they're looking for? And again, what you've got on there, the website on the Members tab, are helpful tips, the sample request to produce and sample interrogatories. And also, what is sitting on there too is from my friend Mark Oshiro, who is out of town today, otherwise he would have been here speaking as well. He has donated for all of you to use, and everyone watching later on video, a motion for protective order and a motion to compel, and some slides from a presentation that he did at this CLE a while back. That's all sitting in that area. There are some differences between state and federal. Do we have anyone that regularly practices in federal court? Okay, good number of people, and the rest, obviously, state court. No other choice, right? The differences here, in federal, you basically have two rules that really deal with eDiscovery, Rule 26 and Rule 37. 26 is your meet and greet up front, and 37 is the sanctions. These rules are on a 5-year amendment cycle. The first ones came in 2005. The last ones were just amended and went into force in December of last year. So we are now operating in 2016. We're operating under the December 2015, obviously, rules. There are some source materials for this as well about the changes and that cycle on the members area, it's the Sedona Conference materials. And there's actually a website for the Sedona Conference where they discuss changes to the rules, so you can get out in front of this stuff and you can look and see in a few years what will be coming in the next amendment cycle in 2020. The biggest change that occurred with the 2015 amendments were proportionality. The concept of proportionality was built in specifically to Rule 26. And preservation, burdens, and the potential sanctions were revised into Rule 37. This is actually, the part in red is what actually changed in Rule 26. And the proportionality concept of eDiscovery that has been gaining in momentum since the 2010 amendments now is embodied in the actual rule that the request in federal court, the request has to be proportional to the case. So if you have a case that's a relatively small case and you're asking for eDiscovery and the cost of the eDiscovery is going to, let's say the case is $500,000. That's the amount in dispute in the federal case, and you've got all the jurisdiction and stuff like that. And you want to do eDiscovery, and the eDiscovery is going to cost $3 million to do. You're going to run right into this rule. The federal judge is going to say, absolutely not. Now you have to prove to me why it's necessary to spend so much in the case. It has to be balanced. That's what they're looking for. The concept of proportionality, you've got to balance this stuff out. How is this going to flow into state court? We don't have this specific rule in state court, but what can state court judges look at? Anyone? The federal rule. There you go. So the concept is the same. It holds true. Cost shifting was also built in. That's the protective orders for cost shifting. The federal courts now that they've got 10 years of this stuff regularly going on in their courts, more so than our state courts, they're looking at the costs and they're saying, wait a minute, if this is going to cost a lot of money, we've got to talk about cost shifting. Rule 37, the sanctions rule, this brings in two very specific new areas, if you will. It brings in the obligation to preserve, and it brings in this concept, this brand new, unique concept that it can't be replaced. So a party has to violate the obligation to preserve the data, but that in and of itself isn't enough anymore. When the rules first started out, it was, oh, well, they didn't keep the data, they had a duty to preserve it. Okay, now we're going to cut their head off. That's the sanction. What it has shifted, that pendulum always kind of swings back and forth as the cases develop under these rules. What we're seeing now through two cycles of the amendments is now the federal courts are saying, whoa, not so fast. Okay, there was an obligation to preserve the data. That was not met. But what's the harm? You've got to now show an additional level. You've got to show, to get these sanctions, that you can't get it from anywhere. It's lost forever. That's what's changed. That's the big difference. A couple of cases that have come up. Cat 3 was January. I say Rule 37 is more lenient, not meaning that it's easier to get sanctions. It's that they have changed the tone. It's not so much that under the new rules, under the 2015 amendment, that the courts are willing to jump on the parties and say, okay, you violated the obligation to preserve the data, now we're going to string you up from a yard arm outside of the courthouse. Leniency is sort of the court, instead of leaning forward in the saddle, as the saying goes, kind of leaning a little bit back and saying, wait a minute, okay, they didn't preserve it, but you've got to show another step. You've got to now show to the court that this is the worst thing that could ever happen on the planet before we're going to start entertaining sanctions. Living Color versus New Era Aquaculture is a Southern District case that Judge Mara decided. And this came up with a new four-part test for spoliation sanctions. As you know from the beginning of the presentation, I am the current chair of the Business Litigation Board Certification Committee. And every year we update our examination for board certification. And just like in the bar exam, there's an essay and it asks people to go through all these different steps and things. This Living Color case is so complex and so convoluted that if you read this thing, it's going to make your head spin. I was thinking, gee, this might make a good essay question on that test. But then I thought, you know what's going to happen? One of two things. People taking this exam on their laptops are going to spill coffee on the laptop and shut it, or just break down crying. That is how complicated this case is. This thing has got a company in England that winds up filing bankruptcy in the middle, licenses coming over here to the States, people that leave the company and go to a competitor and steal information, and emails flying back and forth. I don't know how they could have tracked it all. It's incredible. When you read this thing, you go, wow. So what came out of it, thanks to our own Judge Mara locally, is this very simple 4-part test. And it's just 4 questions, and if they're answered yes, you get your sanctions. If they're answered no, it's not. But a very interesting case if you want to look it up, Living Color.
Is that in the handout here?
That is, I think I put it on the website. If not, you can just pick it up on Westlaw or Lexis. If you Googled Living Color versus New Era Aquaculture, you're going to see a lot of articles written about it because it was the first one under the new rules to come up with this easy 4-part test. But don't Google it now and don't read that case because you're just going to pass out. We're going to have to call the ambulance or something. It's that complicated. Nuvasiv versus Madsen. This is a case where the court was dealing with an adverse inference instruction. And what came out of that under the new Federal Rule 37 was that you've got to have record evidence to now get an adverse inference instruction. And that, again, is going to trickle down into our state courts, and eventually our judges are going to look at something like this and say, so we've got to treat an adverse inference instruction akin to an injunction. We've got to have record evidence and we've got to have a finding to base it on. Otherwise, the appellate court is not going to uphold it. There is a group called the eDiscovery Institute out of Washington, D.C. And this week, earlier in the week, they had their leadership summit in Fort Lauderdale. And there was an article that came out on Legal Tech News, which is a national publication. And in fact, the author of that is going to be here later covering this event. So you'll all be in national news. Unfortunately, people watching on video won't get that privilege, but you all here are going to be in national news media. And they had a number of federal judges come to this event. And talking about these cases and the new federal rules, some of these judges said that there's a sure way to annoy them, which is to disregard the new rules and to make overly broad requests in eDiscovery. One particular judge out of the Southern District of New York who came down said, it's the not thinking lawyer that drives me crazy. So the judges are looking at the lawyers and saying, it's your obligation to do this. We're not going to do it for you as the judges. The last part of the article by Samantha Joseph said there are 2 myths. This was one of the judges speaking on a panel. The myth of human review, that it is somehow better than electronic, and the myth of the perfect review, there is no perfect review. Those 2 things are very telling because you cannot rely on the software to do all the work for you in eDiscovery. It's a tool. You don't lose the human mental component that has to look at and analyze it. The software is making it easier for you, and there is no perfect review. Sometimes people are going to make mistakes. The courts understand that, and the courts have to account for that, and that's why these rules are somewhat softened. There's not the aggressive posture any longer in the federal courts, and that's going to trickle down into our state courts. So when we talk about our state courts, we have now eDiscovery rules in our rules of civil procedure that came into force in September of 2013. So we've now got 3 years of these rules in place, but we really, other than one case, Nucci, we really haven't seen any cases coming out of these particular rules because it takes time for these issues to come up. It takes time for these issues to work their way through the courts and then go up to the appellate courts and to go up to that level and be written about. So in the coming years, we'll see more and more state court opinions under these eDiscovery rules, but not so many yet. There is no meet and greet in our rules, like the federal rules, like Rule 26. And there are no specific sanctions like Rule 37. But do we need them? We have one saying yes. Do we need those rules? Well, what we have at our disposal is the Case Management Conference which is a specific rule that the court can call a case management conference, or you can call for a case management conference for anything, for any reason. So you can use a case management conference as a meet and greet, as a substitute. If you can't get the other side to cooperate, if they won't give you help in doing the search, or they won't meet with you to discuss it or anything, you can set a case management conference, go into the judge with a proposed order, and say, this is what I've tried to do. I can't get to first base with these folks. They won't even give me search terms. They're unhelpful. I don't know what they want. I want to avoid unnecessary litigation, and I want to avoid wasting the court's time. Here's my proposed order. I want to bifurcate discovery. I want to do this part and this part and this part. And as long as you give the judge a reasonable basis, there's no reason why you can't work things out. And that's what you can use a case management conference for in the eDiscovery context. And of course, discovery sanctions. We already have them. They exist. They've always existed. The same cases that were under all the paper stuff still apply to this one. We've got a whole series of levels for the courts to go through of sanctions, all the way from the lowest level to dismissal or adverse jury and adverse inference instructions to the jury. That still exists. That framework is still there, so we don't need it in the state rules. There's no reason why you can't go back to old sanctions cases that already exist and say, this is the same. And we're not dealing with a piece of paper, we're dealing with an electronic document, but it's the same concept.
What?